Good afternoon, everyone. Thank you in advance for staying with me for the last session of the day. When engineers and lawyers talk, right-sizing your data protection risk profile. I realize I'm standing between you and the virtual ice cream social. So let's try to wrap this up on time. I'm Rafae, Bhatti, Director of Security and Compliance at Mode. My social media handles in case you want to get in touch after the talk. So what do? I build data protection programs at startups. Like I said, currently at Mode, I was previously at another startup called HealthTap, and prior to that at New Relic, at that time a pre-IPO company as well. It so happens that I am also a licensed California attorney. And on this journey in my career, I view my role not so much as a lawyer, but as a legal engineer, an engineer trained in the law and its application. So what is this talk about? The thesis of this presentation is that practical engineering insights go a long way in simplifying data protection compliance. In practice, the biggest hurdle in addressing compliance needs is recognizing the most important risks for a company based on its unique risk profile. For example, what type of data can you collect, process, and store? What type of controls are adequate or reasonable? What type of obligations should you accept or enforce? The answer to these questions is rarely one size fits all, but rather based on the company's specific scenarios. However, the path to navigating data protection risks is often filled with uncertainty. Overestimating the risks stifles growth, but underestimating them can derail the business. Just like when you are driving too fast, you may risk getting a ticket, but if you drive too slow, you may not get to your destination on time. So to be able to measure data protection risks and right-size the risk profile of a company, we need to view them from both a technical and a legal lens. What you see in this picture is a scientific phenomenon called parallax. Parallax is the apparent displacement of an object because of a change in the observer's point of view. Astronomers use this technique to measure distance to the stars. In our world, parallax occurs when engineers and lawyers view the threats to an organization from different perspectives. So to address this dilemma, engineers and lawyers need to do something they don't usually do. They need to talk. Anyone knows what happened when an engineer and a lawyer walked into a bar? Yeah, nothing, because they never did. Except in this case, the sentence ends with, and he orders a drink. Because that engineer and lawyer is both one person. And he is talking to you right now. So when I walk into the bar with myself, what do I see? I'm able to see data protection risks from both a technical and legal lens. And in my experience, it distills down to the following. The biggest transition that engineers have to make is viewing things from data subject's perspective. Because in the world of data breaches, it is not just about authorization, it is about reasonable expectation. It's at the core of GDPR, CCPA, and almost all data protection laws. So what does it mean to honor data subject expectation? It means getting clarity on the risks that are introduced throughout the data lifecycle. For example, if you use customer data for other than business purpose, you are liable. Once you have the clarity of purpose, you must implement controls to allow data to be used for that purpose. This includes not just technical security, but also contractual obligations, both upstream and downstream. So if your vendor or partner misuses your customer data, it's a breach that you are liable for. And the controls must also be adequate and reasonable given the type of data and the purpose of use. Implementing reasonable controls that correlate with reducing the data protection risks. You may need to do risk calibration or trade-off to prioritize the most important risk based on their associated legal consequences. But how exactly do you right-size your risk profile? Let's take a look at examples from real life. Suppose you are driving a car. When do you buckle your seatbelt? Always. It does not depend on anything. How about turning on your headlights? You do it when the visibility is low. That's what it depends on. And when can you drive while drunk? Well, as long as your blood alcohol level is below the legal limit, technically you can. I'm not endorsing that though. But really, the point of this analogy is this. There is a risk in driving without headlights or under the influence. And the risk depends on technical and legal aspects. For example, the risk of driving without headlights depends on the level of ambient light at which visibility is low. Technical perspective. But it also depends on the legal interpretation of when the visibility is considered low. For example, as codified in this Mississippi statute. How close to dusk or dawn? How dense of a fog? These are questions for legal interpretation. You could choose to drive with headlights turned on at all times, but that is overestimating the risk. Or you may choose to drive without headlights turned on until the sunset, which is underestimating the risk. Data protection obligations, in a way, are no different than the driver's manual. Let me explain with another example. Suppose turning the headlights on or off is analogous to turning encryption on or off. Whether or not the data should be encrypted is a function of whether it contains personal information, technical perspective, such as pattern matching. But it also depends on the legal interpretation of what is considered personal information. What patterns to actually look for. Keeping the data always encrypted, even in memory, is overestimating the risks. But never encrypting the data, even in storage, is underestimating the risk. A good trade-off would be keeping it unencrypted in memory, but encrypting in transit and storage. And while this is a simple example, it illustrates the idea of right-sizing your risk profile. So now that we have outlined the basic idea, let's put it into action. The best way to understand what right-sizing the risk profile looks like in practice is by using example scenarios. And that's what we're going to do in the remaining half of the presentation. Here's our first scenario. A company retains personal data of consumers for analytics purposes. A California resident asks them to delete all data you have about me under CCPA. Can the company keep the analytics data? First of all, why is this even relevant to security teams? Depending on how big is your legal team, most startups don't build out a legal team that early on. It would be the security and engineering teams who are called upon to decide when and what data can be retained to meet a specific business objective. At the minimum, even if you have a legal team, you will be expected to ensure that the data retention policies are in compliance with your obligations. Now, that can be a tricky balance to maintain. You may not have the leverage to defend product expectations around data retention? We know that the answer here is it depends, but what does it really depend on? The underlying purpose. CCPA has exemptions if the purpose is internal use, such as internal reporting on data derived from product usage, or security analytics on audit logs to prevent incidents. The takeaway here is we have to tie the retention of data to the underlying business purpose. If the purpose is internal use, and if it's consistent with customer expectations, then retaining the data is okay. But not being able to meet those legal exemptions is going to put you at risk. Let's go to the second scenario. A company's vendor launches an email campaign using the personal data of the company's users. The data belongs to consumers in California. Can a California consumer sue the company for a CCPA violation? It's a standard security practice to evaluate vendors when they are processing personal data. So how can a vendor that passed your evaluation end up having legal consequences for you? To answer that question, we need to understand the concept of data sharing under CCPA, and in particular, what it defines as sale of personal information. Data that is shared with the vendor is considered sale if it's used for any purpose other than providing the services. And for all data considered as sale, consumers will have a right to opt out, which you must honor. What this means is this: a non-breaching vendor that has otherwise passed your security review can cause a data breach merely by a change in consumer preferences. This was not true before CCPA, but it's another reason to pay attention to data protection risks. Let's take a look at an example. Say you have two tools. One is a UI tool vendor that helps pinpoint bugs in your UI. The other is your customer support portal or ticketing system. Which of them do you think accesses PII? You may think that the UI tool vendor does not, but it may still be accessing PII in the way it's integrated with your system. So it should be audited for data use. For example, cookie audit. Very few vendor security checklists actually include a cookie scan, but you would need that to mitigate your data protection risks. As for the vendor with customer PII, it must still continue to be held accountable. For example, if it starts to use PII for purposes other than customer support, like email campaigns to promote its own business, that would be a CCPA violation and considered unauthorized sale. So the takeaway here is that we should tie PII audit to vendor security review. Security teams can help prevent accidental risk accumulation by auditing the use of PII by vendors. If the use of PII by the vendor for non-business purpose does not stop, then the customer in California can sue the company. Now let's take a look at the third and final scenario. A company accidentally shares a report belonging to organization A with organization B. The data belongs to consumers in the EU. Is the company required to notify the consumers of a data breach? Third-party sharing is an example of how data breaches may result merely from poor navigating of data protection risks that can lead to compromise of consumer expectations. Now, unlike the previous two vendor scenarios, this is a situation where the breach has already happened. So really, the opportunity to avoid the risk has passed. However, accidental sharing is a reality and can happen to anyone. What can the security team do now? Well, we can help prevent a bad situation from getting worse. Let's look at a really famous example of how one person did that. This was Captain Sully, who landed Flight 1549 on the Hudson. Now, this is an example of finding clarity in uncertainty. Sully made a decision based on risk profile for Flight 1549. Is the speed too high? Is the altitude too low? And how much time there is to decide? If he did not have the clarity of what the risks depend on, then we can all imagine why that wouldn't have gone so well. So coming back to the breach scenario, typically you also have limited time to decide. And how would you decide if you require a notification or not? Once again, it's going to be based on your unique risk profile. The right answers can make a difference between a crash and water landing. Was the data exposed included personal data? Was it encrypted? Has the source of breach been addressed? And by the way, the outcome may be different based on if it's California or the EU. In California, under the CCPA, if none of this was true, then no notification is required. Under GDPR, however, you also have to consider if the processing was high risk. And what is high risk processing? Say you have two applications. One is used to share reports with your users about their utility bills, the other about their clinical tests. And say you have a filter that is used to select the recipients of these reports based on the zip code. And you enter the zip code incorrectly, so the reports go to unintended recipients. In one case, the billing info gets leaked, and in the other, the test results. Processing of billing data, even though personal, is unlikely to be high risk. Why? Because it's used for providing a public service. Not so much for clinical tests. The expectation of the patient would be for this data to remain private. So the processing of health data is considered high risk. Therefore, under GDPR, this type of accidental sharing would require notification to the EU consumer. So our final takeaway is that focusing on data processing risks helps guide breach mitigation and response. Tying the risk of disclosure back to the business consequences should drive prioritization of the security agenda. But also keep in mind the analysis changes in California, and both cases will be equal priority. It's worth noting that if you understand the risks, you will reap the rewards. When you understand the risks, you can translate them into business needs. When you say, this helps me avoid business consequences, so this is high priority, it's more effective than simply saying it's a risk without tying it back to business. Why is that important? Because needs get buy-in, risks get a workaround. They will ask you to find another way. Security engineering teams should also harness the power of awareness around data protection risks to create security culture. GDPR, CCPA is good guidance that is becoming law, and we can use the momentum to our advantage. Lastly, more and more security teams are now recognizing how data protection risks are tied to the security agenda. Privacy engineering roles are on the rise. I've seen a lot of companies put out recs for them. Take a look at your unique profile and make a business case if you need to hire one. Again, demonstrating the need would help you get the buy-in. So yeah, there you have it. We've all been hit by the birds at one point or the other. Hopefully you are taking something away from this talk that helps you avoid a bad situation or prevent it from getting worse. I'd leave you with this anecdote. After Sully landed Flight 1549 on water, he got in touch with the airline operations manager. That person, however, cut Sully off, saying, I cannot talk, we have a plane down in the Hudson. To which Sully said, I know, I'm the guy. So here's hoping when it's our time to land, we are on the Hudson, not in it. With this, I conclude my presentation. Here's my contact info if you'd like to get in touch. Thank you all.